Coming from the CPA book, another video. This one is going to be dealing with the there we go, Fair Debt Collection Practices Act. Okay, that's what we're going to be dealing with today. And basically, under the Fair Debt Collection Practices Act, this is the law that debt collectors, it doesn't matter who they are, banks, credit unions, any company that's claiming that you owe them anything is under this law. Right? And go to the bottom, so you see that the Federal Trade Commission enforces this act. So whenever these people are violating any of these things we're about to go over, you're going to contact the Federal Trade Commission and you're going to put in a complaint. All right, you're going to put in a complaint with the Federal Trade Commission. Once you put in a complaint to the Federal Trade Commission, then they're going to get at these companies, and you ain't going to do much. You know what I mean? But we're going to go through this just to give you people just heads up real quick on about debts. You know what I mean? And how to handle debts. Again, we're coming out of the CPA Excel Exam Review Study Guide. This is the regulations. These are the laws, the rules that they must follow. All right. So again, like I always like to say to the people, no conspiracy here. This is all real talk. This is real law. All right. Now here it goes. The first one is a collection agency. Collection agencies are prevented from contacting debtor or consumer at inconvenient hours, inconvenient places, or at work if employer objects. So if they're contacting you at work, your employer would have to object to the fact that they're contacting you at work. Other than that, they may be able to do that conditioned upon how they're doing it. If they're, obviously if they're being, ridiculous with it, you know what I mean, preventing work from being accomplished, then yes, you can, you can have them stop from doing that. Also, generally prevented from directly contacting debtor represented by an attorney. And this is why some of the people who, once you get an attorney, you know what I'm saying, once you have an attorney, the debt collectors can no longer contact you directly. They have to contact the attorney and work through the attorney in order to get whatever they're trying to get out of you or settle the matter like that. All right. However, we do not use attorneys because when you use an attorney, obviously you got to take money out your pocket. Also, the attorney does not work for us. And I know that's contrary to what a lot of people believe. They think that the attorneys work for us. And I'm going to make a video about that with just nothing but the laws and the proofs showing that the attorneys do not work for us. If there are anyone who's a member of the bar, and by the way, the bar, it's an acronym. An acronym is a word that's created from a collection of other words. So the bar, the definition of bar is the British Accreditation Registry. British. And they say that you cannot practice law in the United States, not America. In the United States, you cannot practice law in the United States unless you're a member of the bar. And then you get at some thought. Just sit back and get at some thought. You cannot practice law in the U.S. except if you're a member of the British Accreditation Registry. Interesting, folks. Very, very interesting. Give that some thought. Why can't you practice law in your own country unless you get permission from Britain? All right. And people don't think that that Britain actually controls this country. They own the World Bank, by the way. So, collection agencies may not use methods that are abusive or misleading. So they can't contact you and act like they're other than who they are. They can't pretend to be a different company or something like that. They can't tell you that, hey, anything that's false. They can't do that. They have to tell you exactly who they are and what they're here to do or why they're contacting you. All right. So they cannot be abusive. They can't start screaming at you on the phone. They can't curse at you on the phone. And I've heard stories of people having to deal with this type of stuff with debt collectors. They can't threaten you. We're gonna send you to jail. All that stuff right there is all illegal. All that stuff is illegal. If you can't get the person's name on the phone, get their name. All right. If they try to get the phone number, any information that you can send to the Federal Trade Commission and send them at them, then that's what you do. You get that information and you send the Federal Trade Commission after them, and they're gonna come and get them. It doesn't matter if they give you a fake number. They will find them. They will find them and they're gonna do it. All right. So next one is the debt collector must provide debtor written notice of amount of debt and to whom the debt is owed within 5 days of first communication. So within 5 days of their first communication. So if they send you a letter, they have 4 more days to notify you and let you know that, hey, this is what you owe, and you owe it to this person or this company or this agency or this corporation. All right, they have to let you know. Usually, for the most part, they're pretty efficient in that, because they when they contact you, they straight up like, listen, you owe this amount of money, you want it. You know what I mean? So this part right here, you rarely find any problems with them not fulfilling. The other it's a law. These are laws. When debtor contests validity of debt, and this is what we're going to be dealing with today. When debtor contests validity of debt, collection attempts must, in law, the word must, it means must. It means you have to. It means that you don't have a choice. You must cease until collector sends debtor verification. This is the law. All right? Nobody's making this stuff up. And this is why our debt letters, they work. Every single time they work. All right? Now, the only thing that we may face with these companies once we start sending these debt letters and they're written correctly, the only problem that we may find with these companies is that they want to test you. They want to make sure that you are who you say you are. In other words, the stuff that you're sending them, you know what I'm saying? You're like, oh, this guy probably just found this stuff on the internet. So they're going to try you and see if you know what you're talking about. You know what I mean? To see if you really know what you're doing. You know what I mean? And I gave the other video where I showed where I was dealing with child support, and they took the I sent the first debt letter, and I'm going to show you guys that letter again today. I sent the letter, and because they saw the facility, they saw that I was incarcerated, they saw I was in a facility, so they tried to play, like we ain't got to honor this, so we'll just play with this guy. He probably doesn't know what's going on. He probably bumped into a guy in here in the jail or whatever, and the guy gave him the information. Wrong. So they sent me a bunch of nonsense, not signed by the judge, not having my signature, not certified, and a whole bunch of other things. And then I'm gonna show you guys what I did to them. And now I got them locked into a lawsuit, and I'm about to start filing the paperwork on them real soon. And I'll show you guys the results of that also. So the debt collector must bring suit in court near the debtor's residence or in jurisdiction where contract was signed. All right. If the debt collector violates the act, that person is liable for actual damages plus damages such as court costs and attorney fees. Federal Trade Commission enforces this act. All right. So if they violate any of these rules, all right, you can get them. You can get the debt collector. They're personally liable. Whoever's sending the paperwork, whoever's getting the paperwork, whoever's shuffling the paperwork around, whoever's filing the paperwork, they are all liable. And you can file a tort claim against them. All right? You can file a tort claim against them. You can file criminal charges because by them coming at you, telling you, hey, you owe this money, you know what I'm saying, and you don't actually owe that money, then that's extortion. They're guilty of extortion. So that's a criminal charge. So now what do? You contact the Attorney General. And you tell them, I want to make a complaint. I want to make a criminal complaint against these guys. So once you file that criminal complaint with the Attorney General, they're going to send you the paperwork. You fill out the paperwork. Just state what happened. Don't need to lie. Don't embellish the story. State exactly what happened. And then send it back. The Attorney General will take care of it. All right? Now, and then also you want them to send you a certified copy of your complaint. And the reason why you want a certified copy is because you're going to make a copy of that, and then you're going to file a complaint with the insurance commissioner of your state. Once you file a complaint with the insurance commissioner, they're not asking any questions. They're not conducting an investigation as to whether what you said is correct or not, or whether the person is guilty. They don't care. The insurance commissioner does not care. All they know is that they have a criminal charge against this company. They have a criminal complaint against this company. And the insurance company, it's an insurance company. They are about their money. So if this guy's going to be a liability to us, then we're going to cut ties from this guy so we ain't got to pay the insurance on him. And this goes for judges. This goes for prosecutors. This goes for attorneys. This goes for police officers. This goes for deputies, deputy sheriffs. This goes for the sheriff himself. This goes for correctional officers, any one of them. The warden of any jail, you know what I'm saying? The CEO or CFO of any corporation or company, they're public servants, you get them. You file that criminal complaint with the Attorney General, and then you take a copy of that and you file a complaint with the insurance commissioner. The insurance commissioner automatically puts a lien on their bond. They cannot conduct business. They have to shut down until the court case gets settled. Then all you gotta do is just, make sure you tell the Attorney General to stretch the court case out. Stretch it out for 2-3 years. They're out of business for 2 or 3 years. The judge cannot sit on the bench for 2 to 3 years, whatever, however long you want to stretch that court case out for. They can't practice on the bench because they don't have insurance to cover themselves because they're practicing law. Attorneys also, prosecutors, the same thing. Excuse me, folks. Okay, so now, who do we report it to? We report it to the Federal Trades Commission. You also want to report it to the Federal Trades Commission because the Federal Trades Commission is going to come at them with a slew of other violations from within their policies and procedures, and it's over for them. Okay. Also, another remedy that we have is you may use a cease and desist order against the debt collector. In other words, you can get a court order to the court, and the judge will give a judicial determination, a ruling, ordering them. It's a type of injunction. An injunction is something that's used to prevent someone from harassing you any further. Excuse me, one second. I'm turning this up. I'm kind of thirsty. Hold on. All right. Excuse me, folks. I'm back. All right, here we go. So, so you can get an injunction or a cease and desist order. And then the next remedy is civil lawsuits, which we just mentioned briefly, for damages are also allowed. So you can actually sue them for money for damages there, because for trespass, trespass on the your rights, titles, and interests on your estate. And your estate, again, is everything that your name is attached to. All right, that you can consider as being belonging to you. This act applies to collection agent collecting debt for another. Does not apply if creditor collects own debt. So if you actually have a contract with these companies, this actual company, and again, we have to understand these people play games, all right? They play games. What happens is these companies will deal with a company, and the company will they'll have a contract with us. You know what I'm saying? For court. You know what I'm saying? Court cases. You know what I'm saying? Child support and all that other stuff. The contract is with the court. So if you're not getting a letter from the court themselves, if you're not getting a letter, you're getting a letter from child support bought that debt. And by the way, child support is a privately owned entity. It is privately owned. It is not a part of the government. And if you watch my last video, you will see for yourself. When I hit them with that debt letter that I'm about to show you, and I'm showing you the actual letter, all right? When I hit them with that letter, they responded back. You can see it was clearly shook up because I gave them, I believe I gave them 21 calendar days, not business days, calendar days. That counts the weekends also. 21 days. Now, mind you, I'm in prison, and I sent them this affidavit. And on the 20th day, that paperwork was in that facility. And the facility I was at, they were notorious for making you get your mail a week to 2 weeks late. These people made sure that they got that stuff to me within 21 business days. Why? Because they was going to go into, it was going to establish an estoppel. An estoppel is basically it prevents them and stops them from being able to take any of this matter that we have, this disagreement, this controversy into a court. And I will go over it when I do the debt letter. But so that was the stipulation that I put on it. And they hurried up and they got it to me in 20 days. And what they got to me was a bunch of copies with nothing certified, nothing signed, none of that stuff. Which means what? They never responded. And they didn't send me any affidavits, and I mandated that, I stipulated that they would send some affidavits also. They have to send affidavits to rebut my affidavit. They never sent me affidavits. In law, what that means is I won. Why? Because in law, the first one to leave the battlefield, the first one to give up, the first one not to provide what they're supposed to provide, they lost. And an affidavit, a judge cannot override an affidavit. So an affidavit has a higher status, and a lot of people get surprised when they hear this. An affidavit has a higher status than the Constitution of the United States. How is that? Because the Constitution has what's called amendments. Now, think about it, folks. When you amend something, that means you're fixing something that needs repair, or you're adding, or you know what I'm saying, you're perfecting something. All right. So the Constitution can be changed. It can be amended. An affidavit, it must be rebutted. It must be rebutted. Otherwise, it stands as absolute fact. It's just like the sun in the sky. All right. An unrebutted affidavit stands as an absolute fact in law. If it's not rebutted, it is the truth. Everything else is false. All right. So now, when you have an affidavit and you submit it into the court, and they do not rebut it, and oh, by the way, I'm gonna show you something real quick. You have, let's see. Okay. So in the affidavit, if you have, let's just say you have 10 points on your affidavit. I have the issue, this right here. I'm saying this is true. I'm saying number 2 is true. I'm saying number 3 is true. Number 4 going all the way to 10. All right. And you submit your affidavit. And somebody, anybody tries to rebut your affidavit. If they try to rebut it, what happens is this. If they rebut 1 point in your affidavit still stands. If they rebut 4 points in your affidavit, it still stands. It's not rebutted. If they rebut 9 points out of your 10-point affidavit, your affidavit, it still stands. If they rebut 10, then your affidavit has been rebutted. It has to be 10. All your points that you put in your affidavit, if they leave anything out that they don't rebut and they don't prove that it's not correct, then your affidavit still stands. They have not rebutted it. So when they sent me that paperwork without a judge's signature, without my signature on anything, without the certification, it does not matter that they sent me that paperwork, because you did not rebut my affidavit with another affidavit. And those forms, I stipulated in my affidavit that I wanted them sent to me in a certain way. My signature, the judge's signature, my with my seal on it. It didn't have my seal. It wasn't certified. None of that stuff. So that stuff can't even be used in court if it's not certified. So, worthless. And they sent no affidavits to rebut what I said. So what does that mean? That means that their stuff is trash. And my affidavits still stand. So now, we're going to go into my affidavits. It's the debt letters, and they are affidavits. We're going to go into that right now. Let's go grab them. 1 second. All right, folks, here we go. So this one was the first one that I sent to them. And this one is the one that I usually give to people. And I tell them, basically you got to copy it down. Take my information out. And as you can see, look. Post Office Box 975, Coxsackie, New York. That's Green Correctional Facility. That's where I was at. Green Correctional Facility. All right, so nobody's freestyling this. And on the second page, you'll see, look. And there's the notary. All right. There's the notary. You want to look up his number? You can look up his number. Google it. You know what I'm saying? To Albany. The man's in Albany. Google it. You'll see it's a real number. The man really exists. The document is real. I definitely sent this out to child support, and they tried to act a fool, and we got them. So anyway, going to the first part. You're gonna put your heading up there. You know what I'm saying? Then you're gonna put the name of the affidavit. You're gonna name the affidavit. Well, I mean, you can use this title if you want to. It's no problem. You know what I'm saying? This is a title that we came up with. You know what I'm saying? If you want to use it, you can use it, or you can name it whatever you want to name it. You know what I'm saying? Affidavit of truth and demand for verification of debt. Notice the agents, notice the principal, notice the principals, notice the agent. All right. Again, if it's not really clear, just screenshot it. Just screenshot it. I'm trying to keep it still as possible. Put it at a good angle so you can see. All right. So basically, okay. My name, executor, paramount title holder. To the all capital name estate. I'm in receipt of a letter from your office with a New York case identifier number, and you can look this number up. It's real. They might have taken it off their books, but you can look it up. Alleging a fraudulent debt, and that's the date they contacted me. I have never been presented with any sworn affidavit. And this is what they're supposed to do. Whenever they're contacting you, you know what I'm saying? They're supposed to be presenting to you what's called a true bill in commerce. It's an affidavit. A true bill in commerce is an affidavit. It's a form. You know, there's no real form to the way in which you write an affidavit. All right? And let me see. Where did I put that? I'm trying to think. I have some of the paperwork that they sent me from the child support, basically telling me to fill out this form, and it looks like an application form. It's like a bunch of blocks and spaces or whatever. You add this information in here, check this box, and all this other stuff. And basically, it was it tells them about my financial state. You know what I'm saying? It gives them the ability to look into my accounts and stuff like that, and see how much assets I have. So anyway, it looks just like any other form. And at the bottom of it, it says affidavit, a financial disclosure affidavit. So you would not even know it's an affidavit unless you read that, you were paying attention. You just didn't look at the form and get scared. These people contacted me, oh my God, I better pay them. You know what I'm saying? Pay attention to what these people give you. Read this stuff, man. They try to put pressure on us to make us hurry up and sign. You know what I'm saying? Hurry up and sign. You know, like what was it? Menace to the Society or whatever it was. Hurry up and buy. Yeah, hurry up and buy. You know, they want to hurry up and sign. Right? Just go ahead and sign it. Don't worry about it. Don't worry about the fact that you're signing your life away. So anyway, I didn't go for that. So I said, I have never been presented with any sworn affidavit nor any commercial affidavit which will provide any validity to your claims and or assessment. Right? Assessment is how much they're saying that you owe. It is therefore my best and considered judgment that no such documentation and or affidavits exist. If what you claim is based upon any substantial and or verifiable facts, I demand that said facts be produced and presented to me for my inspection. Mind you, folks, this letter was written off the top of my head. And it's not no bragging. I'm just letting you know this is the stuff that happened inside the facility. You know what I'm saying? So I'm letting them know, according to my best and considered judgment, I really thought about this thing. I don't think this stuff exists. So this is what's called a conditional acceptance. All right, this is called a conditional acceptance. A conditional acceptance is in law a way to say no. I'm not going to do something or pay something or whatever, but you still remain in honor. And how do you remain in honor? You remain in honor because you're saying, if what you claim is based upon any substantiated and or verifiable facts. In other words, I'm not going to pay because I don't think it exists. But if it does exist, just prove it to me and then I'll pay. If you can prove it, then I'll pay. All right, so then next line. I further demand, and this is all demands. I'm not asking anything. I'm not asking you for nothing. You guys are public servants. I don't have to ask you for nothing. I'm demanding it. I further demand from your office a complete record of all books of accounting and ledgers. They don't want to give that up. And this is why a lot of these companies run when they get this letter. All right, they run, they take off. Child support's been doing dirt for so long, and they're under the opinion that people believe that they are actually a part of the government, and people are spooky about the government. You know what I'm saying? Listen, first of all, it's not the government that's doing it to people. It's the people that work in the government. And if you don't realize that it's people that's doing this to you, they're running game on you, you know what I'm saying? Then you're going to find yourself in a situation to whereas they're always going to be emptying out your pockets. You know what I'm saying? You have to realize it's not the government doing it to you. If you look at the documents that the government is based on, you look at the laws that the government has put in place, you know what I'm saying? Those laws are in our favor. They are all in our favor. But there are people who study the law. They study it and they look for loopholes for themselves so they can cash out. All right? So stop being afraid of the government. The government is not after you. The government is a 10-page document in Washington, D.C., okay? The government's not after you. There are people who work inside of the government who are doing this to you because you do not know the law. You do not understand economics, and we should start learning. Learn the small, easy stuff. And when you learn the small, easy stuff, then you keep growing from there, step by step. You learn a little bit more and a little bit more. And the next thing you know, they can't do nothing with you, man. They really won't be able to do anything with you. Watching these videos, they'll help you. These are small steps. You know what I'm saying? These are not major steps. These are small steps. But they're still steps. And when you start doing this stuff and start utilizing, you start seeing how this stuff works, I'm telling you, you're going to get a charge. You're going to be like, hell yeah, let's get it rolling. Let's do it. You can't wait to do the next one. You be sitting there, I'm serious. Like a lot of times we be sitting back just rolling our fingers, man, rolling our hands, man. Can't wait for the next company to come. Because now we're going to start charging them. Charging you for contacting. You know what I'm saying? So now, next line. I further demand from your office a complete record of all books of accounting and ledgers. They're never going to do that. Including, but not limited to. And in law, the word including, it means does not. It's a negative. All right? So that's why you always put including, but not limited to, because including means only this one point after including. So you say including, but not limited to. Don't leave it at that one point. It's everything else. Including, but not limited to, any and all contracts compelling my performance. Bring me all those contracts. In accordance with said contracts. All right? Please take notice that all contracts must bear my wet blue ink signature. In other words, I want the original contract. Seal, which is your right thumbprint, and be certified for my inspection. So it must be certified. Otherwise, if it's not certified, it can't be used in court. I want certified documents. Send me some certified documents. If you have it, send me the certified documents, because that will prove that I actually owe you. If you do not send me any certified documents, that means you have nothing to go into court with. You know what that tells me? That tells me that you bluffing. You're bluffing. And you know you're bluffing. And they know that they're bluffing. And that's why they also run away. Because they cannot bring you anything certified. Because what they're doing is running a scam on you. In the event of any failure to provide said documentation, this respondent, right, not defendant, not this debtor, don't put your name on that particular point there, at that particular point. You're going to say, this respondent demands, again, more demands. I'm not asking anything. I'm not asking for no favors. I don't want you to look out for me. You know what I'm saying? I'm demanding these things because they're my rights. Whatever's your right, you can demand. You have a right to demand your rights, but you must demand them. All right? Okay, so this respondent demands that all alleged, right, so said, alleged debts be recorded and officially acknowledged within your records and other agencies as non-existent. In other words, take it out of your records, man, and stop playing with me. And I also want you to do what I also want you to do is let all these other agencies, and that would be including but not limited to, again, right? Including but not limited to all debt collection and or credit reporting agencies. So Experian, Equifax, credit, any of these credit unions, you know what I'm saying? In other words, this right here, this letter is geared towards getting rid of the debt and also clearing up your credit score. This one letter gets rid of the debt and clears up your credit score. All right? Okay, so now we're going to finish this thing off. Because when you write an affidavit, you're going to state what the issue is. You're going to state what you believe is the solution. And then you're going to tell them, here's your or else. In conclusion, here's my or else. If you don't do what I'm telling you to do, this is what I'm going to do to you. If it be your offices or any agent acting on behalf of your office, and that means everybody's included, nobody's left out. Anybody that puts their eye on this document or puts it in their hands, if it be your offices or any agent acting on behalf of your office, determined intention to dishonor my wishes in this regard, in other words, persistence in any further attempts at extorting monies from me or my estate, in violation of Title 18 USC, subsection 1951. And that right there, Title 18 USC, subsection 1951, is the law for extortion. And it says that even if you gave the money, but you didn't want to give the money, that's extortion. So, you sent them this letter. You're letting them know, I don't want to give this money, man, but you guys are making me. So if you make me give you money, then you're extorting me. That's a crime. You can report it to the Attorney General. I will be left with no recourse except to file a criminal complaint and a commercial lien against your office. Commercial lien will be the UCC1 financing statement. You go on the Secretary of the Treasury site website, and you can file a UCC1 financing statement. That's what we use to become a secured party creditor. Okay, and okay, I got you. All right. Somebody just sent me a message. Y'all didn't see it. I don't think y'all saw it. But anyway, a commercial lien. The way that you do a commercial lien is you go on the Secretary of the Treasury's website, on her page, and then you on the right hand side, there's going to be a list of things. You're gonna click on UCC. Once you click on UCC, then you're going to see a list of UCC joints. You're going to look for UCC1 financing statement. All right. Once you get the UCC1 financing statement, then you fill out the necessary information. We're going to do a video on how to fill out a UCC1 financing statement and put a lien on it. This is exactly when you go to get a car, when they put the lien on your title, the exact same way. It's the same paperwork. It's the same stuff. They're doing the exact same thing. We don't know it, so we can't do it. And now that we know how to do it, I'm going to show everybody how to do it. Let's start putting pressure on these people and stop letting them get over on us. Stop letting them put their hands in our pockets, man. All right? So we're going to make videos for that, man. So we can show the people how to do that, man. So people will leave us alone. Commercial lien. I'm going to put a complaint and a commercial lien against your office, as well as all agents acting in concert. Everybody. Nobody's free. Nobody's exempt from this. Anybody who puts their hand on these documents, I could put a lien on them too. I could put a lien on them. I could put criminal charges against them because they're participating. Is what they call it, RICO, right? RICO. They're conspiring. It's conspiracy. You guys are conspiring to extort me, to extort monies from me. So I put every single one of y'all. Anybody whose name is on the paper, you know what I'm saying? Anybody who was in that office, who the paper may have came across their hands, whoever passed it along, passed it up, passed it down, it don't matter. Everybody's liable. Everybody. Nobody's exempt. Jointly and severally. All right? Meaning individually. In your official capacity, so I can sue you as the clerk, the agent, or whoever you are acting in that capacity, I can sue you for that because you're working on behalf of the company. And I can sue you as well as in your private capacity. I can sue you as an individual. So let me tell you what that means. If I sue you in your official capacity, right, that means I get your checks. I get those checks. I sue you in your private capacity, that means I get your pension. So everything is mine. Everything is mine. I'm suing you in both capacities. So everything that you own will be mine. All right? Now, let's go further. Check this out. This is the money. This is the money maker right here. This is nice. Any refutation of the aforementioned and or the following issues must be done so. If you're going to try to refute this, it must be done so on and for the public record. All right? On and for the public record. In writing. In other words, by affidavit. And I'm going to say that too, just to be more specific. By way of a sworn affidavit, like you see in front of you. A sworn affidavit signed in their full Christian/family name, because this is what they go according to: Christian name, your family name, whatever. So we put their terminologies in there. All right, signed in their full Christian family name. In other words, you can't put an assumed name on the document. It has to be your real name, because I want to get the real person. I'm coming for you. All right, under penalties of the law, including but not limited to perjury. All right. An assessment of how much? Let's get a close up on that. We need to make sure we got a good look at that. Boom. 200,000. Yeah. 200 stacks. I want 200 stacks. An assessment of 200 stacks for each issue. And occurrence of perjury, false, misleading, unproven statements, assertions, or information shall be what? Deemed due and owing upon the claimant. In other words, as soon as you do it, you already own it. We ain't got to wait. We ain't got to figure out nothing. As soon as misleading information, child support, what do? They sent me a whole stack of misleading paperwork. Unproven statements. Nothing was certified. Nothing was signed by the judge. Nothing was signed by me. It's all unproven. So each one of these situations, they misled me. Every single form that they sent me, it's a misleading form. So what? $200,000 for those forms. Each one of them. Not all together. Each one, 200,000 stacks. 200 stacks. Unproven, 200 stacks for each one of those forms. Assertions, you're asserting that I owe you, 200 stacks for each form, right? Or information, meaning misinformation, 200 stacks. False, 200 stacks. And they're lying, that's perjury, 200 stacks. So you do the math on that. I did the math, it came out to about 7 million. All right, so and I gave him my tabulation sheet. You know what I'm saying? My tabulation of violations. Sent that to him. I'm gonna show you the other affidavit. I don't think I have a copy of the tabulation sheet, but you can do the math if you want to. Came out to like 7 million. And plus, they gotta pay for me to respond back to them. So if you want me to respond back to you, okay. Well, I charge $2,000 to even send you back any mail. $2,000 just to send you back some mail, plus postage. So 50 cents. $2,000.50. I want it. It's mine. I want it. I had to spend it on you dealing with your nonsense. You got to pay me. All right? Everything. I'm not playing with you. So, it will be deemed due and owing upon the claimant. Whoever claims it, whoever sent me the documents. No other refuting documents will be accepted. If you're not sending me affidavits, it's not accepted. Now, here's the money. Here's the real money right here. Failure to respond within 21 calendar days will constitute a complete agreement and estoppel. And again, estoppel means that you can't bring it up in any court. All right? You've been estopped. You've been estopped from bringing it to court. So, jurat literally means a person who witnesses the document. All right? So the jurat is the notary in this matter. All right? That's the jurat. All right? Silicet, the SS Silicet, is the acknowledgement. The acknowledgement, when you put acknowledgement on your documents, is telling the jurat, which is the notary, to ask you, are you the one that wrote this document? Not anybody else. Are you the one that wrote this document? And then they'll ask you, did you write this document? And you say, yes, I wrote this document. Now, mind you, I'm going to show you maybe later on, I'll do another video about that too. But here, if you notice, I have New York State. It's all in lowercase. Greene County, well, we put Suffolk County initially because that's, my documents, I'm from Suffolk County. But I was in Greene Correctional Facility at the time, so we crossed out Suffolk County and wrote in Greene. All right, Greene County. Okay, so now whenever you write it in lowercase, you're letting them know what jurisdiction you're operating in. You're not operating in the illegal jurisdiction, the corporate constitution. We're operating on the common law, the original constitution. And in other words, you're toast. I'm not playing with you. You're toast. So anyway, and this is what's called a notary block. This whole section right here is called a notary block. All right. On this day, 11th day of the month May in the year 2018, came before me the below signed notary public. This person, all right. He's a clown too because he tried to play me on the second affidavit that I was sending to them. This clown said he didn't want to sign. He doesn't. He said he didn't recognize me as being the executor and paramount title holder. I said, well, that's who I am. And he's like, well, I don't really know that. And I said, listen, let me tell you something. I said, I understand because Greene, they're foul. All the officers in that facility are foul. They be doing some real dirt. I ain't gonna turn this video into a war story about Greene, but them officers they be smacking dudes in their face and all that, man. But they, like my man used to always say, his father used to say, he said, a monkey know what tree to climb. So, for the most part, if they knew the dude, he don't know nothing. He ain't gonna be able to retaliate in law or nothing like that. He ain't gonna be able to do nothing to me or whatever. They'll smack him in the face, punch him in the face. I seen the officer punch dudes in his face. The officer in my house, the house that I was in. This dude, I saw him choke one dude out, slam him against the wall, punch another dude right in his mouth, swole his lip up, and then moved him out the house. Let another officer deal with it in another house. Another dude smacked him in his face. This dude was wild. He was out of control, man. But again, I never had no issues with him. You know what I'm saying? Like, he would see how dudes would come over to my cube and, ask questions about the law and stuff like that. And on top of that, in my record, you know what I'm saying, they already got martial arts in my record, you know what I'm saying? So them niggas they part of my language. I don't use the word nigga on my videos and nothing like that. And I definitely don't curse, so. But anyway, we had a healthy respect, man. You know what I mean? We had a real healthy respect. But anyway, this officer here in that corrupt facility, you know what I'm saying? And it's rampant in there. It's rampant. The corruption is rampant. But anyway, this guy was telling me, well, I'm not going to sign off on it. I said, well, listen, let me tell you something. I'm like, as far as being a notary, I don't know if you think that I'm new to this or something. Well, I've been doing this for 3 years. I said, listen, man. I said, it doesn't mean anything. The time, it don't mean nothing. You know what I'm saying? It's about knowledge and information. Do you have it? You know what I'm saying? You can work at a job for 20 years and still don't know how to properly operate within that job because you're just going according to, what everybody else has been doing. You know what I'm saying? Totally breaking the rules. I said, okay, so she's like, well, I don't recognize you as the executive on paramount title. I said, well, that's not up to you. Your job is simply to witness the fact that I am the person that's in front of you. I gave you my identification. My face is on the identification. Here's my face, and I'm telling you that this is me. And I have other documents, but because I'm in this facility, my documents are at home. But I'm telling you, that's who I am. He's like, well, who swore this who put this on the oath? I said, he said, this is sworn to, he said, sworn to who? I said, who swore this in? I said, let me explain something to you. I said, it says swore to because you're supposed to ask me. That's what acknowledgement means. You're supposed to ask me, am I the one that wrote this document? So basically, I'm teaching this notary who's pretending as if he doesn't know, or maybe he didn't know. I don't know, but it doesn't really matter. I'm going to explain it to you if you need that. I am the executor and paramount title holder, and I'm swearing before you, not swearing to you, I'm swearing before you that I am the one that put this document together. Anything you want to know about this document, you ask me, and I'll articulate it to you, and I'll explain it to you, as I just did in this video. You know what I'm saying? So, he did that on the second one. We'll get to that in a minute. You'll see that there's a different notary on there. This one he signed because he wasn't paying attention. When I sent this out to child support, they contacted the facility and told this dude don't sign any more affidavits. That's what happened with that. That's why on the second one he didn't want to sign anything. Child support called the facility, the jail, and told them, do not let him sign any more affidavits. Do not sign any more of his affidavits. Don't let him send any more out. Because they was jammed up. Off the first one they jammed up. They sent me that nonsense, right? So they sent me all the paperwork. If you want to see the paperwork, refer back to my last video. And you'll see the paperwork that they sent me. Garbage, trash. All right? Now this is what I sent to them after they sent me that garbage paperwork. All right? Now when you hear the wording of it, you're gonna see how bad their situation is. So again, you're gonna do the top the same way. Right? You're gonna put your information. If you're gonna do this, you're gonna put your information in it. If you find yourself in this situation, most of you will not get to this point. Most of you will not get to this point. That first letter is enough to make these people run. This one is the affidavit of fault with opportunity to cure. What it means is you guys are at fault because you didn't respond back. All right? And you certainly didn't respond back properly. With an opportunity to cure. In other words, I'm giving you an opportunity to cure your fault, to cure your mistake, to cure the fact that you did not respond back in law. And how do you start it off? In private, independent, administrative process. In other words, it's private. It's just between me and you guys. It hasn't gone to court yet. It's not going public yet. I'm trying to solve this matter privately. Private, independent. I'm operating independently, right? I'm doing this on my own. Administrative, because all this stuff is administrative, all right? Administrative process. So, because some people read this and they're like, what? I don't understand what they're saying. Their legal jargon is very confusing. Article 1, redress of grievance under Ninth Amendment reservations for resolution and equitable settlement under necessity. I'll break it down. Article 1 is one of the articles that's in the law. You know what I'm saying? It's one of the articles that you'll find inside of that law when you look under this article, Article 1. And the name of the article is redress of grievance. All right? And it's under what amendment? It's under the Ninth Amendment. All right? And what is the whole purpose of the Ninth Amendment? This article of redress under this Ninth Amendment. It's reservations. It's reserved for resolution. In other words, solving a problem. And equitable settlement. And being equal in the settlement. Being fair in settling this problem. Under necessity. Because it's needed. All right? Under necessity because it's needed. Okay? All right. So, notice the agent is notice the principal. Notice the principal is notice the agent. Case number, of course. You know this is what it's about. I'm talking about this case. That's R-E. It's not an F. It's an E. All right? It's a little faded. R-E, reason, right? Or regarding. Reason or regarding case number, and then the case number. To whom this may concern, because another thing, they're sending me these documents, they're not sending any names. So you just keep it general, and it doesn't matter because once you start filing your criminal complaints, the attorney general and all these other agencies, they're going to go into these companies, they're going to flash their computers, they're going to audit them, and they're going to find out who these people were that were operating these things. So it doesn't matter. It doesn't matter if they send you these documents without any names on it. Don't worry. Just put to whom it may concern, or to whom this may concern, however you want to put it. To whom it may concern. It's all good. All that stuff is good. I am in receipt of the what? Paperwork. Because you ain't send me no documents. You didn't send me no affidavits. You sent me a bunch of paper. I am in receipt of the paperwork issued from your office having a postage date of 5/24/2018. However, upon my inspection of said paperwork, it has become glaringly obvious that your office has failed to produce any affidavits in support of your assertion and have, in effect, acquiesced means silently approved, silently agreed with me, in favor of my affidavit. The first affidavit I sent, you agreed with it. You silently agreed to it because you did not respond back properly. The requisite points being the following, to wit. All right, the requisite points are, we're going to list them right down here. The required points they were supposed to answer. Requisite, required. All right. To wit, in other words, as for what follows. Right. And in the Arabic we say I'm about. Right. I'm about. As for what follows. To wit, same concept. One, this is what I asked for in my first affidavit. I want an affidavit of rebuttal, point for point. I want that. You didn't give me that? Okay. An affidavit signed in your full Christian family name of the rebutting party. Whoever's rebutting, I wanted that full name. They didn't give me that. They didn't send me any affidavits. A complete record of all books of accounting and ledgers. They didn't send me that either. They sent me a bunch of papers saying, showing me the times that I did pay when I was on child support, and I didn't know what the heck I was doing. I didn't know nothing about this stuff here, this law stuff and this economics and all that. So yeah, I was paying. I paid them. And I definitely no deadbeat dad, so I wish somebody would say something like that. I'll show them those documents and a few other things. Number 4, any and all contracts compelling my performance. In other words, where's the contracts that say that I'm going to pay this bill? You know what I'm saying? That I'm lawfully obligated to pay the bill. That you guys provided me with anything to make me obligated to pay the bill. They didn't give me that. So you have no contracts compelling my performance in accordance with said contracts. All contracts must bear my wet blue ink signature. I must have signed it in blue ink, because that's how I sign. I sign in blue ink. All right? They didn't have that. In other words, I wanted the original contract. They didn't give me that. They didn't provide me with that. So they're already a violation of the Fair Debt Collection Practices Act, which we read earlier. All right? All contracts must bear my seal, my right thumbprint on my name. That's my seal. It doesn't. You saw the documents on. Look in the other video. You'll see there's no signature on there from me or anyone else. Not even the judge. So that means you don't even have a judgment for what you're asking for. And then 7, all contracts must be certified, and none of them are certified. None of them. All right. So now, here's the fun part. This is where it gets fun. All right. In this regard, your office has not satisfied the established conditions. It is therefore my best judgment and belief that you are without any lawfully verifiable evidence or proof to substantiate your past, present, or future actions in regards to this matter. As you have already stipulated meaning in this case in law, stipulated means that you've agreed to. Stipulated to the facts as they operate in favor upon the undersigned, meaning me. I'm the undersigned. Because I sign at the bottom of the document. Hence, your office and all agents acting in concert are now at fault in this regard. Remember, this is an affidavit of fault with opportunity to cure. So I'm letting you know you're at fault. As I wish to resolve this matter, this is where you're being slick with it, being funny with it. You know what I'm saying? As I wish to resolve this matter as soon as possible, it is of necessity, as I can only do so conditioned upon you providing the required documents. Come on, man. Stop playing games, man. Send me the documents, man. I need those, right? I will extend to you 10 calendar days to cure your fault of non-response. If you fail to cure your fault, you will be found in default. And I'm going to share something with the people real quick. Once you go into default, you take that default, you take all 3 of your letters. Your first letter, the affidavit of truth and demand for verification of debt, your affidavit of fault, and then your the affidavit of default. Once you have those three documents, and that's how they do us. It's 3 times. You get 3 notices in law. After you go on your third notice, you're in default. Once you're in default, all they got to do is bring the matter into court, and you already lost. As soon as you go in, you lost. The judge is going to rule in their favor. It doesn't matter how it sounds. They're going to make it sound like you got a chance and all, like you might have a possibility of winning. Once you go into court, 99% of the time when we go into court, even with criminal charges, we're already in default. Because whenever you get a charge placed against you, you have 72 hours to get to the court and challenge it. All right? Or resolve it. You have 72 hours. So by the time we get in the court, that's why they give us those long dates to come to court. We think we got a break. Yeah, man, I got time to chill, do this and that. No, it's a lineup. They're lining you up. They want you to be in default. So when you go into court, you're already in default. So now it's not a one-on-one fight. You're not getting a fair fight. You actually have to fight your way up and out of the default, and then you can fight. And guess what? 9 times out of 10, you lost. They're not gonna let you get out of default. That's why they ignore a lot of our motions and stuff. Well, not mine, but a lot of the people's motions that they put in the court and stuff like that. And they say, the prosecutor, they ain't, the judge, they're not respecting the law. They're not following the law. They're ignoring my motions and no, because you're already in default. They don't have to honor it. They don't have to recognize it. They don't have to acknowledge it because you're already in default. You had 72 hours to respond back, to get to the court, to the clerk, and submit your documents and show you, put your affidavits in there and let them know, listen, I'm an American national, whatever the situation is, you know what I'm saying? And what they saying has happened didn't happen. Boom. 72 hours, you just acquiesced. You silently agreed to the charges that they were putting in on you. 72 hours, you got to get down there. You bring 2 witnesses too. And then you all write affidavit saying that you went down there, you tried to resolve it, and the clerk didn't let you resolve it. Bam. You take that, you get it notarized, you know what I'm saying? You want to get it authenticated, whatever you're going to do. And then take that and mail those into the court. Mail them right to the judge. 1 to the judge, 1 to the prosecutor, 1 to the court clerk, and 1 to, a lot of people don't do this, even people that be claiming that they know what they're doing in law, they do not send a letter to the court recorder, the stenographer. You should send a letter to the stenographer because the stenographer records everything that pertains to the court case. So the judge may tell you, no, I'm not going to recognize it. The clerk may say, we're not going to file it. You send it to the stenographer and you put on the envelope, private. You write the big letters on the side, private. And you send that affidavit, send those affidavits to the stenographer, and you tell the stenographer inside that letter, right, a separate letter, a cover letter, you're going to tell them, I wish for you to place these affidavits into the record for identification. All right? And what that means is I want you to take these affidavits and put them into the case. They are a part of the case now. They cannot be overlooked. They cannot be ignored. They must be addressed. And if the prosecutor does not address it, then the prosecutor has lost the case. And then you can file criminal charges against the prosecutor. All right? So that's just a little tidbit, a little side piece for you. All right? So now let me go back into this and finish this thing off, inshallah. Okay, so I'm giving them 10 calendar days to cure their fault of non-response. Now, mind you, folks, they sent me paperwork. I'm still saying it's non-response. Why? Because they didn't send anything certified, no affidavits. So it is as if they sent me nothing. They did not send me anything. They gave me nothing, so it's non-response. And they were hoping that I would think that they responded back to me, but it was non-response. They did not send me what I wanted. They did not send me what I requested. It is non-response. Pay attention to what they're doing. They play games with you. If you fail to cure your fault, you will be found in default and will have established your default and dishonor of this offer. Right? Because it's all offer and acceptance. All the stuff is offer and acceptance. Next, question. This when you play with them a little bit more. Were you as agent, and I'm talking to any agent, anybody that had their hands on it, authorized by a supervisor? I need you to snitch on your supervisor. If the supervisor told you to do it, I want you to snitch. All right? They're always trying to get us to snitch, right? I want you to snitch on your supervisor. Were you authorized by a supervisor or otherwise by one above you? right, to violate the rights, titles, and interests of the undersigned? Do you take full responsibility and liability for your actions? And if you do, then the undersigned herein accepts your full liability and herein enters a claim on all your property and okay. I'm back. Yeah, cut off for a second. And if you do, then the undersigned herein accepts your full liability and herein enters a claim on all your property and reserves the right to file such claim upon you via your silence or agreement, in other words, acquiescence, or you verbally agree via the UCC, meaning the UCC1 financing statement. That's how you put the claim on them. That's how you put the lien on them. All right, put a lien on their property, and then I'm gonna do a video on that too, showing you how to do the UCC1 financing statement. I already told you I'm gonna do that, but I'm gonna show you how to get the UCC1 financing statement and the other documents. You put them together, and then you file other documents with the Secretary of the Treasury, and then you take those documents, you bring them down to the court, and then you file a complaint into the court, and then you, after like 90 days, you're gonna you get what's called a writ of execution. Writ of execution, you take the writ of execution and you bring it down to the sheriff, because the writ of execution tells the sheriff that they can go to that place and take everything that they own. Everything that's listed in the UCC1 financing statement that you said that is the collateral for them to pay you back. You know what I'm saying? Whatever they owe you, you're going to put in their collateral. It could be their business, could be their house, could be the favorite pair of shoes that you saw one of those workers wearing that you always wanted, you couldn't find it in any store. Yeah, you could list that on the UCC1 financing statement as collateral to be paid to you if they don't settle the matter. You know what I'm saying? Anything, all of your property. All right? Okay. So you put the UCC1 financing statement, you do that, and then you bring the writ of execution down to the sheriff, and the sheriff will go up in there, no questions asked, and they're going to take their stuff. They're going to put locks and latches on their doors. They can't get into their property. Dudes in jail were doing this. They did it to the superintendent. They did it to the officers. And I'm going to show you in another video. I ripped a page out of the rule book in there to show you so you can see for yourself. They put a rule in there saying that you can't put liens on anybody. They don't want you putting any liens on any of the staff because dudes was putting it on the officers. They did it to the superintendent. But some of the dudes, some not all, some of the dudes was playing themselves because what they were doing was they would get into an argument with an officer, or they'll write the superintendent and tell him to do something, and the superintendent wouldn't do it, and so they would put a lien on him. You can't use it for stuff like that. You can't. I mean, you can, but it's going to backfire on you. You can end up getting locked up for that, for putting in a false claim. You know what I'm saying? You can go to jail for that. You get a new charge for that. And some of them dudes got new charges for that because they were playing games with it. You can't play games. You got to do this thing the right way. You can't play with it. All right. So next line, paragraph. Please take notice. I'm putting them on notice now, right? Please take notice that my name, executor and paramount title holder to the all caps name estate, is exercising his right to verify any such proof, discovery, evidence, or otherwise in the nature means in the way, you know what I'm saying, in this cause, you know what I'm saying, in the nature of his right to challenge debt or jurisdiction at any time. And that's the law. You can challenge debt or jurisdiction at any time. All right. As to the entire matter per his right within due process of law via the Fair Debt Collection Practices Act. So I'm letting them know. Right? That's the due process of law. It's the Fair Debt Collection Practices Act. You must follow those rules. If you didn't follow them, I own you. And therefore, this process, being private in nature, is proper in obtaining such evidence and to challenge any false claims, charges, or otherwise. So this is proper. Me doing this is proper according to the law. All right? I'm letting them know. So act right, in other words. As such, you, acting as agent or agents, on behalf of New York State Child Support Processing Center, having superior knowledge, and this is where you blow their ego up to make them, you want to boost their ego. You know what I'm saying? Sun Tzu, in The Art of War, he explained that, one way of defeating your enemy is to make your enemy believe that you're afraid of him. Make your enemy believe that you're afraid of them. And what that will cause your enemy to do is become lackadaisical and easygoing about their approach when dealing with you. They're not going to, they're not going to bring their best forth. They're not going to bring forth their best effort. You know what I'm saying? Because this guy's already scared of me. I'm just going to beat him up. I'm just gonna probably hit him a few times, but then he says as soon as you see your enemy weak or lackadaisical, he says then you strike hard and you strike fast, and make it a decisive victory. You know what I'm saying? So this is what we're doing here. Having superior knowledge of the law, right? And access to the proofs. So I'm letting you know, you know the law better than I do. I'm weaker here. You know what I'm saying? You know the law better than I do, so that means you better also hold yourself to account. Right? You know the law better than I do, and you have access to the proofs. You can get me those documents, or so I believe. Right? Or so I want you to believe that I believe. But I know that you can't get them. You cannot get those original contracts. You can't. Why? Because the standard practice ever since 1980, no, not 1989, 1998, I think it was. No, I'm sorry. Oh man, what was the exact date? Holy crap. I believe it was 1989. Matter of fact, it was 1989. 1989. No. Since 1989, since the computer boom started to take off.
1998 is the correct
date. They started
date.
to destroy the physical paper contracts. After they make a contract with you and stuff like that, they take the contract and they destroy it. Why? Because they take that contract, they make photocopies of it, right? They'll scan it, you know what I'm saying, and put it inside of a computer and log it that way. Why? Why do they do that? Because the computer age, you can now store information. I mean, virtually unlimited amount of information in the computer. Now, they don't have to pay for warehouses to house these papers and documents, right, to prove this stuff. And, they don't have to hire security guards to watch over this paperwork and stuff like that. They don't have to do all of that now. They can save money just by making copies of it and put it inside of the computer. All right? And on top of that, these people are stupid. They're dummies. They don't even know the law. Nobody knows the law. Nobody knows about contractual law. They don't know that we're supposed to have that original contract. We're never supposed to get rid of it. And who's going to challenge us? They're already scared of us. Right? They're already scared of us. So what do? They take all the contracts. After 90 days, after you've signed everything, 90 days later, they destroy it. All right? They make the copies of it, they destroy it. Now, here's the problem for them. Once they destroy the original contract, they are not the holder in due course. They are not entitled to the money. They are not entitled to anything once they destroy the original contract. Now, once you challenge that, they better produce the original contracts. And this is why when I told them, give me the certified copies, they did not give me any certified copies because they cannot certify those documents because they don't even have the original. You cannot certify it if you don't have the original. It's over. The fight is over. So people, stop being afraid to do this. Stop being afraid. Okay? So now, and have access to the proofs, and are now, and this is what I get them, you have superior knowledge of the law and access to the proofs, and are now under real obligation. I'm telling you, this obligation is real now. I'm telling you, you better produce this stuff now. I'm not playing with you people. And are now under real obligation to provide such proofs as demanded herein above, to inform the undersigned secured party. I'm a secured party. In your document, you will take secured party out because you're not secured party yet. I'll show you how to do that. Secured party of your right in law over any earnings and or wages and garnishment of the same from the estate of the undersigned secured party, having a superior claim already in place. When you become a secured party creditor, you have a superior claim. And if your office does not provide such proofs, then you will have evidence upon yourself as agent or agents, injury, trespass, and damage perpetrated against the undersigned secured party, for which, here's where you cash out, for which I require a $5,000 indemnity payment. Indemnity means to make you whole again. After they've damaged you or broke you or took something from you, indemnity means to make you whole again. So $5,000, I'm saying, is going to make me whole. All right? $5,000 is going to make me whole. I require a $5,000 indemnity payment from your office and or agents. So either the office is going to pay me or the agents, or all the agents can get together. Everybody can get together, come up with this $5,000, and that will shut me up, and I won't file no criminal charges, no cases against you guys. For purposes of offsetting any offense, for purposes of offsetting any adverse effects which the undersigned secured party has been made to endure, resulting from your error in presuming any right to garnishment of wages and earnings for my estate. Right? And I'm not saying me, I'm saying for my estate. Should you fail to honor this indemnity offer, the defaulting and dishonoring party will be foreclosed on by locks and latches via UCC, meaning UCC1. They know what you're talking about when you say that. In addition to the following actions to be taken. So not only am I going to do the UCC on you, the UCC1 financing statement on you, I'm going to do some other stuff to you. Check me out. Okay, boom, here's the money. To wit, right, again, as for what follows, formal criminal charges filed in the Office of the Attorney General. Complaint filed with the Federal Trade Commission for Fair Debt Collection Practices Act violations. Complaint filed with the Internal Revenue Services. IRS. Watch this. Criminal Investigation Division. For what? For theft of funds without due process of law. You're extorting me. Right? And that's a taxable issue. You're taking money, dealing with money. It's a taxable issue. Tax evasion, because you're not filing the tax forms telling them that you're taking this money from me. And sedition against the bankruptcy of the United States of America. Right? Or the United States. Because the United States is bankrupt. And you're operating in sedition. You're operating against it. You know what I'm saying? And against the bankruptcy. And the bankruptcy is that one of the rules of the bankruptcy is that when the Fair Debt Collection Practices Act, that's a part of the bankruptcy. That's the laws of the bankruptcy. So when you're challenged, you must produce what they're challenging you about. 4 is complaint filed with the Insurance Commissioner of New York State, accompanied by the criminal complaint. This is also, just pay attention to this, because what I'm saying to them is, I'm going to put a complaint with the insurance commissioner, but I'm not just going to put a complaint in with them. I'm also letting them know that I know that if I file the criminal complaint filed in the Office of the Attorney General for processing, if I submit that criminal complaint, I know that it will put a lien on your bond and you're out of business. So I'm letting them know on an indirect, like, I'm not playing with you. You're going to go out of business. Don't play with me. You know what I'm saying? This is letting them know on an indirect, and they know exactly what it means. They know what will happen if I do this. Please see tabulation of fees and violations on attached form. And I told you I don't have the tabulation sheet. I don't have a copy of it right now, but they definitely got a copy of it. I sent them a copy of it. All right. So any refutation. This is the usual one that This is my little block right here. My conclusional block. Any refutation of the aforementioned and or the following issues must be done so on and for the public record in writing by way of a sworn affidavit signed in their full Christian family name under penalties of the law, including but not limited to perjury, an assessment of $500,000 now. Why? Because you guys played games with that $200,000, and now that I see that you guys are willing to play games, I'm bringing the price up. You want to keep playing? I'm letting you know that I'm not playing with you. And you want to keep letting this money stack up, then let it keep stacking up. Or you could just give me the $5,000 and leave me alone. Okay, so it's $500,000 for each issue and occurrence of perjury, false, misleading, unproven statements, assertions, or information shall be deemed due and owing upon the claimant. No other refuting documents will be accepted. Failure to respond within 10 calendar days now. You're only getting 10. 10 calendar days will constitute a complete agreement. You're totally agreeing if you don't respond. Estoppel and default. It's over. And again, jurat is notary, acknowledgement, and New York State lowercase, where I know the jurisdiction I'm coming out of. Greene County is where I was at, and I'm let them know I'm in this jurisdiction, and the notary block, the usual. All right. Boom. And that's it. And as you can see, like I said, there's a different notary that signed off on this one. Actually, when I went to the parole board, this lady here, she was running because they do it by camera now. They do it by camera. All right, you don't actually sit in front of the board people anymore. They do it by camera. But she was running the camera, and obviously I didn't see her. I didn't know her. So when I went to get this thing notarized, she was like, "Oh, Mr. Booker." She was like, she's like, "You don't remember me?" I'm like, "Remember you? No, I don't know you." She's like, "Oh," she's like, "You know what? No, never mind." She's like, "I was the one that was operating the cameras at your board." I'm like, "Oh, shoot. Okay." I was like, "Oh, so how did I do?" She's like, "Well, I can't really say. I'm not allowed to say." I was like, "Okay." I said, that's fine. I said, but in your own opinion, you know what I'm saying? What do you think? What do you think it looks like?" She's like, "You know what?" She's like, "In my own opinion, if it was up to me, I think you made it." And then I left it like that. I didn't want to say anything more. I was like, okay, sounds good to me. So she's like, oh, so this is your document. I was like, yeah, boom, boom, boom. Because she had to do the acknowledgement. This is your document, yes. Da-da-da-da. You wrote it, yes. And so she was like, sign. So I signed. And there was no problem. I signed, and she signed. She stamped it. It was official. And that week, I sent it out. Oh, look, I love when a plan comes together, man. Look at this right here. Okay. Remember I told you affidavits have different forms? Right? There's no specific way to write an affidavit. Look, this is an affidavit. It looks like any other kind of form. It's the form that they sent me for the court. They wanted me to go to court and deal with the child support. It's the one I smashed. I smashed the court out on the phone, over the phone. They sent me this. They wanted me to fill out all this information, giving them a free reign into my estate and my assets and all that. It's voluntary. You don't have to fill this out. They'll make you think that you do, though. Now I'll prove it to you. Look. What does it say? Financial disclosure affidavit. Short version. And what did I say? A non-obligatory, it's non-obligatory, public disclosure of your entire private estate. You don't have to tell them this. The Fourth Amendment of the Constitution. You have a right to, what is it? Oh, you have a right to be secure within your person, papers, and effect. Your papers is your finances. Your finances is your papers. You have a right to be secure within your person, papers, and effect. In other words, you don't have to turn over your books and let these people know how much money you're making, what you're doing, what you own. None of that. All right? According to the Constitution, you have a right to be safe and secure within them things. You ain't got to give it unless you choose to. And that's why I said this is non-obligatory, but it is a financial disclosure. If you put that information in there, you're doing it voluntarily. So anyway, you will be opening every door and window for them to enter and then take whatever they like. That would be foolish. Backside. More stuff they want to know about you, right? Medical, everything. Once again, financial disclosure. This will be their evidence that they will use against you. Oh, look. Sworn to before me on Notary Public. What is it? It's an affidavit. Signature. It's an affidavit. It's an affidavit. They send you an affidavit. Basically use against you. What you say can and will be used against you in a court of law. And these people are not playing when they tell you that. We are being brainwashed and trained to think that people can say what they don't mean. And it's okay. And that's why when people talking to me, I tell them straight up, listen, man, mean what you say. You tell me you're going to do something, you know what I'm saying? You better do it. You say something to me, I hate you. Then I accept the fact that you hate me. And I believe you. I didn't mean it. I don't care. I do not care. Once you tell me that you hate me, you mean it. You mean it and you meant it. And guess what? You're going to always mean it in my mind. You're going to always mean it in my mind. And that's not me being just mean and bitter. No. You better mean what you say. Because when you get into the habit of saying what you mean and meaning what you say, when you come across documents like this from these people, and these police tell you what you say can and will be used against you in a court of law. They're not playing with you. I'm not your friend in the precinct. I'm joking with you. I'm talking about the cop. He's joking with you. He's laughing with you. He brings you coffee. He brings you all this stuff to soften you up. Everything that you say in law, it can be used against you. And guess what? It will. I'm telling you, I'm going to use it against you. You don't want to believe me? It's your own fault, stupid. It's your own fault. I'm telling you what I'm going to do to you, and you still go along with it. This right here, what you say on here can and will be used against you in a court of law. Let's smarten up, people. Okay? Let's smarten up. And that's it on this video. It's a done deal. All right, people, have a good time, good day, good life. Talk to you later on another video.